my name is Priscilla Hawks, and I'm the founder of Hawks Law Group PC. I want to thank you so much for visiting today. I want to talk to you briefly about common clauses that you'll find in music industry agreements. And for this video, I want to talk particularly about grant of rights. It'll maybe say rights sometimes, if not grant of rights, but it's the same thing. So I have my phone because I'm going to actually read you a little bit of a clause. But in this section, what you're looking for is, and when I say you, for purposes of this video, I mean you as in the artist. What are you giving up? What are you giving away? What are you granting? You are going to be considered the licensor in this circumstance, granting certain rights to the licensee. So I've had people come to me before, and they're not really sure what they own, if anything. They don't know if they own their masters. They don't know if they own their publishing. They don't know what kind of rights they have to anything, quite frankly. And so this is definitely one of those sections. You want to read it very carefully, and you want to have a lawyer that's versed in entertainment law really go through it with you so that you can be clear on what you own. So just to read a little bit, I'm not going to read this whole section, but I want to show you how the language is so that if you are in a situation where you have a contract before you now, some of this may sound familiar, and so you know, like, oh, okay, I need to get someone versed in entertainment law to go through these this section with me so that I can be clear about what I own. So, for example, it can read something like this. Pursuant to this agreement, the licensor, again, that's you, grants, I'm not going to say the name here, any and all rights and licenses required to professionally use and exploit commercially or not the master recordings as defined below on an exclusive basis, in parentheses they have the masters, which shall include the sole and exclusive right, license, and privilege for the territory and for the exploitation period provided in Clause 4 to press, manufacture, distribute, sell, hire, advertise, promote, and otherwise exploit the masters embodying artist performances in any manner, entirely or by extracts, including but not limited to the right of communication to the public by all means, whether known or yet to be known, the right of representation in public performance, notably by radio broadcast, television broadcast, and broadcasting by any transmission and or telecommunication network of the master recordings, as well as the exclusive right to use the provided materials, the name, likeness, photographs, and biographical material of the artist, and any reproduction or adaptations of packaging, artwork, in connection with the promotion, exploitation, and sale of records derived from the master recording, and any digital products and services, for example, digital content distributed via cellular phones, personal computers, and other consumer electronic equipment, and so-called interactive voice response services. Name of the person I'm not going to say, or label I'm not going to say, shall also have the right to commission remixes of the master subject to this agreement by third parties. Name of the record label I'm not going to say, shall also have the right to synchronize the masters with moving and or fixed images in order to produce music videos to be used directly or indirectly, commercially or not, in connection with the use and exploitation of the masters. And believe it or not, there's actually more to that. But I'm going to stop there because this is the New York Minute series, and we went well over a minute for this time, but I think it's worth it because in music industry contracts, you have to understand that everything I just read, not only is it wordy, but every little thing has a meaning. Whether you say and or, another word, that changes the entire meaning. So not only do those words matter, but just in general, music industry contracts, when it comes to the rights, if you're not clear on what you're giving up, then that means now as you move forward in your career, when it's time for you to really take advantage of certain opportunities because maybe your music has done well, or maybe you've done well on social media, you won't even really be able to exploit yourself in the way that you want to do so if you don't own anything. So I'm not going to talk in this video about whether or not you should own things. That's going to be a separate video, but I'm going to encourage you in this video to make sure that your grant of rights clause is a clause that you thoroughly understand. And so one of the ways, obviously, read it for yourself, but I would also strongly advise that you speak with a music industry attorney so that they can break it down for you and let you know what it is that this label is asking for and what you're going to be giving up. All right, so that was a bit more, probably a lot more than a New York Minute. But thank you for watching. This is Priscilla Hawks, founder of Hawks Law Group, coming to you in a New York Minute. Thank you.